So this is in the matter of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Phoebe McClure appearing on behalf of the people and Michael Margosian appearing on behalf of Mr. Musgrove. This is the date and time set for sentencing. Mr. Margosian, you did receive a copy of the pre-sentence report.
Yes, Your Honor.
And Mr. Musgrove, have you had an opportunity to review this with your attorney?
Yes.
All right, so I need you to kind of scoot closer to the microphone and I need you to speak up loud so that when we're recording this for appellate purposes that it shows up, okay?
Yes.
All right, so and you've been able to speak with your attorney and discuss it?
Yes.
Are you satisfied with Mr. Margosian as your attorney and the advice that he's given you?
Yes.
Mr. Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
None to my knowledge at this time.
So I show that the probation department has calculated the minimum sentencing guidelines to be 7 to 23 months. You agree with that calculation of guidelines?
Your Honor, I don't have any challenges.
Okay. So Mr. Margosian, I would also note that at the time of the plea, the prosecutor agreed to no initial jail or prison and restitution was determined to be $21,660, and that's what was placed on the record. And of course, the court will follow that agreement. But before the court passes sentence, do you have? You're not really on this case, but I called your name. Do you have anything to say on behalf of people?
No, but let me, I guess, check if anyone's here on it. No, one's here on it. Thank you.
Okay, Mr. Margosian, is there anything you'd like to say on behalf of Mr. Musgrove?
Your Honor, we additionally received the victim impact statement. We've reviewed that. There's nothing substantive that we need to address in that letter. As the court kind of just indicated, I would just ask the court to follow the recommendation of probation with the order of restitution to be paid over the course of probation and to follow the sentencing agreement for no upfront jail. Obviously, that gives Mr. Musgrove the best opportunity to make whole on that restitution. So I think that would be in the best interest of everybody, and I would just ask the court to follow the recommendation.
All right. Mr. Musgrove, anything you want to say in your own behalf?
No, ma'am.
All right, so in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. The sentence of the court will be placed on probation for a period of 3 years. I'll give you credit for time served of 6 days. There is restitution in the amount of $21,660 payable to Hardwoods of Michigan. During the term of probation, you will obey and comply with all the articles of your probation, but some of them will be that. So. I don't see any alcohol offenses, so I'm not going to order the term that you cannot consume alcohol. I am going to order that you can't use any illegal controlled substances and possess any paraphernalia. You must use all prescription drugs only as prescribed. Have any assessments done as required. Complete any counseling they refer you to. Not have or use any object as a weapon. You must submit to search of your person and property, including but not limited to your vehicle, residence, computer, phone, without need of warrant if they feel they have reasonable cause to believe you have items that would violate the terms of your probation. So does that mean 605 a month? Ms.
Yeah.
Holly? Okay, so what I'm gonna have Ms. Holly do is she'll set up a monthly amount you must pay towards this to make sure that by the time your probation's done, you've paid it in full, okay? So, and you must do execute a wage assignment when you're employed and not miss any payments. There's a crime victim rights assessment fee in the amount of $130. Like I said, restitution in the amount of $21,660. There's a $30 per month supervision fee, $60 if we have to put a tether on you. I don't think that would be a problem. $750 in court costs. There's $450 in attorney fees and $68 state costs. No $60 DNA fee, I think, because he's had it done recently.
Correct.
Okay, so anything else, Ms. Holly?
No.
Okay, so Mr. Musgrove, my bailiff's gonna hand down to you your notice of right to appellate review. We're gonna have your initial and date one copy to go in my file just to acknowledge you received the paperwork, okay? The other copies are for you, and if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right?
Okay.
And do you want him to chat with you today?
Tuesday between 8 and 10.
Okay. All right, so Mr. Musgrove, Ms. Holly, I just need you to report to her Tuesday between 8 and 10. Is that all right?
Yes.
Okay, so good luck to you, and the record should reflect I've received back a signed copy of the notice of right to appellate review. Thank you, Ms. Musgrove.
Thanks.
Denver Warren, no. Let's see. Are you ready on Xavier Williams?
Can I talk? He's in jail. Is he on screen?
Let me look. Let me check my jail list. I don't, oh yeah, he is. Let me call him. Miss Tim, he's at the top. Hi, this is Judge Anselone. How are you today?
Oh, I'm doing fantastic. How about yourself?
Just marvelous. So I am looking for Xavier Williams.
Mr. Williams, okay?
All right, thank you.
Yes, ma'am.
Bye-bye.
Bye-bye.
Mr. McCready, have you had enough time to review the file?
Yes.
Can I have the file back? You can approach. We'll pull over to the jail.
Judge, the jail said they would make that person available in the next 10 minutes or so.
Thank you. Making me nervous. I keep thinking I'm forgetting you, Sam, and I need to call your client.
I made you nervous.
I'm like, did I forget Sam again?
I would let you know if you forgot.
All right. So is anybody else in here a defendant that I haven't called their case yet? What's your name?
Denver Warner.
Okay, and you are Matt Murphy's client, right? All right, so Mr. Murphy's next door, and then he'll come back. All right, will you text him to make sure he comes back? Not to forget him. All right, Mr. Murphy, we have Mr. Warner. Are you ready, Adam?
I am, Your Honor.
All right. Mr. Warner, you want to come stand up here with Mr. Murphy? Do we have anybody on this file to speak? No.
She was here, but I think she went out to the vehicle. Yeah.
All right.
I'll make a brief statement.
Okay, this is in the matter of the people of the state of Michigan versus Denver, James Warner, file number 2024-21676FH. I have Phoebe McClure appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Warner. As I said, this is the date and time set for sentencing. Mr. Murphy, you received a copy of the pre-sentence report.
Yes, Your Honor.
And Mr. Warner, have you had an opportunity to discuss the pre-sentence report with your attorney?
Yes, Your Honor.
Are you satisfied with your attorney and the advice that he's given you?
Yes, Your Honor.
All right, Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
No, Your Honor.
Do you, Ms. McClure?
No, and I haven't been getting the misdemeanor ones. I don't know if we're supposed to or not. And I have no reason to dispute anything at this point.
I thought they all got delivered to you somehow, but.
Yeah, I thought they did too. We just haven't been getting the misdemeanor ones.
All right. So, Mr. Murphy, I show he has a couple prior offenses. Do you wish to, does it disclose any prior convictions which there exists any known constitutional defect?
No, Your Honor.
Before the court passes sentence, is there anything you'd like to have to say on behalf of Mr. Warner?
Your Honor, in regards to the matter, I believe that probation is appropriate in this matter. I believe the plea agreement was for Mr. Warner to be placed on probation and to suspend any jail time. In this matter, I'd ask the court to follow that. I believe it's appropriate. I understand that Mr. Warner, he's trying to comply. He's trying to do what he can to make change in his life. I understand there's hiccups, but he's here today. He doesn't flee. He doesn't try to avoid the situation. In regards to this matter, in regards to this case, I believe he had served a sentence of 30 days or more in district court on a probation violation from this incident. So again, that's one of the other reasons why I believe that more incarceration because he did serve some time based upon this incident. So I'd ask the court again to just continue Mr. Warner to have him on probation, to continue him out of custody, to suspend any jail time. And I believe, Your Honor, that he understands if Your Honor is to suspend any jail time to not incarcerate him, that he's given an opportunity and he's going to use that opportunity appropriately, Your Honor.
So, Mr. Warner, is there anything you'd like to say on your own behalf?
No, I have been going to AA.
You got to step in front of the microphone and speak up.
No, but I have been taking AA regularly though. Okay, pathways, help myself with alcohol.
And you quit your counseling with Mr. Bailey?
Mr. Bailey.
Were you doing, I showed that,
John Bailey, yes.
but you're not doing it.
No, I have, I've done the $50 domestic violence class, but I have other classes I do have to take, yes. I just talked to my probation officer yesterday about those.
Is there anything else you'd like to say?
No, Your Honor.
So the reason they're recommending you're in jail is because you do very dismally on probation. You tend to violate probation and not be compliant. You understand that if I give you probation, you're going to have to do these things. And if you don't, I'm going to put you in jail. I mean, I don't know what the truth of it is, but the impact statements I have is that you tried to have her claim your sister caused the assault and not you. So you're like throwing your sister under that bus just so you didn't have to go to jail. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing.
Judge, I hate to interrupt, but could I?
Oh, I'm so sorry.
No, that's
Yes.
okay. I was trying to
forgot
find
you
a
said
good
that.
break.
Sorry.
No, that's okay. Just a couple things. Part of the agreement was for this offense, no upfront incarceration. However, that did not preclude him from getting any incarceration on that probation violation for that case from June 2023.
Which he did.
Okay, and I thought that was the case. But another part of this agreement was that his 7694A status on that prior case was to be revoked. So I want to make sure that that's happening.
I don't do that. I'm a circuit court judge. So district court, that case is downstairs, so that would have to be done down there.
No, I know that, but I just want to make sure that he's aware that that was part of the.
That was part of the plan.
Yeah,
Yep, it was
okay.
clearly stated on
Because
the record.
the same probation officer, I believe, is going to continue to supervise him down there, so that is going to be their recommendation if it's not already happened.
Did it already
And,
happen, Mr. Murphy?
I think so, Your Honor. I'll go down check after this.
yeah, and I'll follow up also with the probation. I just want to make sure he knows that that's happening. So at this point, this is going to count. If he gets another one, we're gonna know, well, one, he's not gonna have the benefit of delayed status. But if he gets another domestic violence, I think this one was only a felony because it was aggravated. The next one will be a felony because it'll be his third offense. As it relates to contact with the victim, it's my understanding they've had contact the whole time. She, you know, it is what it is. I think if the court's comfortable with it, you know, I don't want to see him be violated continually for having just contact with her if that's something that she's initiating as well. So I guess if the court's comfortable with it, you know, they're gonna do what they want to do. Maybe we can lift that no contact. But obviously if there's any assaultive contact, that's gonna be a problem. It's gonna be obviously a violation, but also another felony potentially. So I'll leave that in the court's discretion. I just wanted the court to be aware of that.
Ms. Adams, could I get a district court probation term sheet, please?
Yes.
All right. Now, anything else?
Nothing further, Your Honor.
The criteria and reasons for the sentence and the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of law, and the protection of society. So it'll be the sentence of the court, you'll be placed on probation for a period of 24 months. And I will order 1 year in jail, but I will suspend it upon any violation. So you understand, if you're not compliant with any of the terms of your probation, you're just gonna serve that year in jail. Got it? How old are you now? Okay, so I'm gonna order no alcohol, no illegal controlled substances. You must continue all programming with John Bailey, comply with it and attend. So if you're not doing it, that's a violation, you understand? Are you employed?
Not at the moment.
Okay, is there anything stopping you from being employed?
No.
All right, you must get a job and maintain employment of at least 30 hours per week. You can probably take all of the seat, or wait, I have actually. So maintain 30 hours of employment a week. I'm gonna order that you attend 12-step meetings, AA. If they require you to have an alcohol or substance abuse assessment, you will do it, all right? There'll be random testing for drugs and alcohol. I don't know, he may put you in colors, depends on what they decide to do. Is it Eric Williams, your probation officer? Who?
Liz, right?
Liz, right, okay. Understand that you, if they have reasonable cause to believe that you violated the terms of your probation, they have the right to search your house, your car, your phone, and your computer. Do you understand that? They can search for controlled substances, alcohol. So no one in your home can have alcohol. Do you understand? Okay. Do you have your high school diploma? Good for you. All right. And I need you to provide at least 10 contacts a week for employment when you report to the probation department. So. And sign releases, no assaultive behavior. Not to live anywhere. All right. And I'm gonna give you a curfew of 10 PM to 6 AM. Unless your employment is different, and then your probation officer can give you permission to leave then. Do you understand? So you're 30 and it's time to get a hold of this, so this doesn't continue to happen. I will commend you that you very quickly notified us the last time you were scheduled for sentencing that you had a medical emergency, so I appreciate you did that. And let's see, there is 700 and let's do $500 in court costs, $450 court appointed attorney fee. There is a $75 crime victim rights fee, $60 in state costs, $100 law enforcement fee, $30 per month supervision fee, $60 if we have to put a tether on you. And then there, let me see, two. I'm gonna do a $100 fine. So it gets expensive. So they will set up a monthly amount that you are to pay. Understand if you don't make that monthly amount, that could be a violation. Do you want to say loudly?
Yes, sir.
Okay. And, okay, so this starts today, but I need you to, next Thursday to probation. Do you want next Thursday? When do you want them to report down to district court for probation? You can report right now. So I'm gonna have your file. I'll actually give it to Ms. Cannon and then she can take it down with her. And you can go down there and wait today, okay? Now you do have the right to appeal this sentence. And we're gonna hand down to your notice of right to appellate review. I need you to initial and date one copy for our records. The other copies are for you. And if you wish to appeal that sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right?
And Judge, just so I might
You
have
can
missed,
approach Mr.
are we lifting the no contact?
No,
Okay,
because of what you said. Understand if there's any problems, Mr. Warner, I can reinstate that no contact.
wait, so we are lifting.
It's not being ordered on his probation for no.
I'm not ordering it right now because you said they have contact.
Yeah, okay. I asked if it was being lifted.
It's automatically, yeah, it's lifted.
Okay,
So the
thank you.
no contact's lifted, but if there's
Thank you.
further issues, I'll put it back in place. So Ms. Cannon has a matter to take care of up here, so I just want you to go sit downstairs in the hallway and wait for the probation department, all right? All right, anything else on that file you need? Okay, thank you.
Yeah.
Okay.
Mr. Murphy.
I know, he'll be all right, he's not running. I'll let him. Mr. Tatum is here, do you need to talk to him or you want him brought back?
I need to speak with him real quick.
Okay.
I'll tell him.
All right.
Thank you, Judge.
Thank you. All right, I have a gentleman joining me from the jail. What is your name, sir?
Edward Mitchell Benitez Jr.
Okay, all right. Mr. Dagmar Gosian, it looks like I also have your client.
Oh, that's true.
I'm not ready yet.
Okay.
Just be a minute. Just be a minute. All right. All right. right, so Mr. Dagmar goes in. I'm gonna open up that breakout room. And don't enter it yet. I'm just kind of waiting for him to turn on the everything. I don't know, wait.
Thank you, Honor. That's fine.
Are you ready for Haley Sebring? Rhonda Underwood, are you ready for Haley Sebring?
Yeah.
Is she here?
She's here.
All right, you can have him bring her down.
Do we need Mr. Benitez?
Yeah, I'll call him. Miss Adams, could you call the prosecutor's office and have Mr. Bayonetto come down?
Okay.
You know how to get in here, don't you, from that door? You can always come in.
I don't think they're spot. Oh, you're talking about going back.
This one, to get in. You can't get out. Back there.
I'm trapped.
You're trapped.
Middle floor?
Hi, I have Jill Zoom 1, but the audio and video is turned off.
Oh, okay, I'll get in there.
All right, thank you. Bye.
Yes, ma'am, bye.
Oh, it's up now. All right, so Jeff, can you let him. Ms. Sebring, you just come up to the podium. Mr. Dagmar goes in, you sneak back. All right, so Mr. Williams, I'm gonna send a request here in just a second for you and Mr. Dagmar goes in to join a breakout room so he can chat with you, okay?
I can hear you, ma'am.
You can't hear me?
I can hear you now.
All right, so the gentleman on the first floor of the jail, I'm gonna put you in the waiting room because we get a lot of background noise from that room. I'll be with you in just a minute. All right, so can you hear me better now, Mr. Williams?
Yes, ma'am.
Okay, so I'm gonna open that breakout room for you and your attorney, okay?
Okay, thank you.
All right, so this is in the matter of the people of the state of Michigan versus Haley Grace Lynn Jeanette Sebring. We have multiple files. We have file number 24-21747 FH, 24-21812 FH, and those, well, I think those are my new ones. Hold on, let me get this all straight. So those are 224s. Hold on, let me get all my 24 files together. I think I mixed them up yesterday. I'm sorry. All right, so we have 3 pretrial files, and those are file number 24-21746 FH, 24-21747 FH, and 24-21812 FH. And then we have the probation violation files, which we already have a pre-sentence report on, but that's not up for sentencing today. And those are 21-20382 FH, 21-20520 FH, 21-20521 FH, 21-20522 FH, and 22-21037 FC, and 22-21038 FH. So those are the probation violation files. I will set those to the side. So Ms. Sebring is represented by Rhonda Underwood, and we have Alexander Bayonetto appearing on behalf of the people. So we were here yesterday and we needed guidelines. Mr. Bayonetto was kind enough to run those. And this morning, Ms. Underwood and Mr. Bayonetto spent a considerable amount of time discussing the guidelines as well as the case, and I was able to join in that conversation. So a plea offer was tendered and there was a discussion regarding that. So Ms. Underwood, how would you like to proceed today?
Your Honor, the plea offer, as it is understood, is that Ms. Sebring will plead guilty to the following crimes. Possession of methamphetamine, a 10-year felony,
And that would be an added count 3.
correct. And unlawful use of a motor vehicle,
Is that as charged?
that is as charged. The supplements will be and file 2421746FH and 23249 OT will both be dismissed with a restitution amount that Ms. Sebring will be responsible for of $336.70.
So hold on a second. You said something, you said OT?
Yeah, there's a misdemeanor file that's being,
Oh, okay, okay.
I need that number again, Judge. I'm
Yeah,
sorry.
I didn't quite catch that number. What's the misdemeanor file number?
23249 OT.
OT. Okay. Okay, and then, it has nothing to do with the probation violation recommendation. All other counts newly pressed along with the habitual offender supplements and, file number 24-21746FH would be newly pressed as well.
That's correct.
Okay.
You're
Is
on.
that a correct recitation of the plea?
I'm not.
Oh, she's not done yet, Mr. Benitez, so let me back up. Ms. Underwood, proceed.
I knew he was going, and
Okay.
there is an agreement, Your Honor, of a 24-month Michigan Department of Corrections minimum. However, Your Honor, boot camp eligibility for Ms. Sebring, the court would approve boot camp after 12 months served with credit for time served,
If she's eligible,
if she's eligible.
right? So,
Is that a correct understanding of every one of the plea?
Mr. Benitez, is that a correct recitation of the plea?
It is, Your Honor. The only thing I would add is that $336.70 in restitution is on the 2421746 FH file, the retail fraud. So the only other thing I had on there was that would be admitted for restitution, which is that $336 that I mentioned.
Do you understand that, Ms. Sebring?
Yes, I do.
And Ms. Holly, just for purposes of the record, so she has a probation violation, which is recommending boot camp. And if I were to sentence her on this file and then boot camp on the other file, would this preclude her from boot camp?
No,
Okay,
not should have any pending felonies.
no, she will be completely done as far as we know.
They said after serving how long?
Well, when I get the notice from MDOC to approve her on these files, I would state that she may be released to boot camp after 12 months. She's got
Okay.
some time already served, so quite a bit. So that should preclude her from boot camp on the violation and on this file.
No,
Good. Okay, so,
not unless she's done any descriptions.
no, she's not. Okay, anything else, Mr. Benitez?
No, Your Honor.
All right, so Ms. Sebring, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, now you are very good about public speaking, so scoot up a little bit towards the microphone. And I do appreciate that. Let me get everything in order. 7-6 is getting, okay. So Ms. Sebring, we've been here 2 days in a row. You've heard everything over and over again. So do you fully understand the plea offer?
Yes, I do.
And you understand that on file number 24-2174, well, is it your intention then? Well, let me back up. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, I am.
Okay. Now, you've heard the statement of your attorney and then agreement by the prosecuting attorney. So on file number 24-21747FH, is it your intention to plead guilty to count 1, motor vehicle unlawful use, which is a 2-year high court misdemeanor? So it carries a maximum penalty of up to 24 months in prison and or a $1,500 fine along with license suspension. So is it your intention to plead guilty to that file?
Yes, it is.
Okay. And then on file number 24-21812 FH, is it your intention on this file to plead guilty to an added count 3 possession of methamphetamine which carries a maximum penalty of up to 10 years in prison.
Yes, ma'am.
And you understand count 1 and 2 would be dismissed as well as your habitual offender fourth offense notice.
Yes.
Okay. Now, neither the well, we've actually talked about a sentence. It will be a prison term of 24 months with the agreement that if you're eligible for boot camp after 12 months, I would allow you to be released to boot camp.
Yes, ma'am.
Okay. But other than that, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Ms. Underwood?
That's correct, Your
Mr.
Honor.
Bayanetto?
Yes, sir.
All right. And is that correct as far as you're aware?
Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have a right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, I don't.
All right, so ma'am, how do you wish to plead to the charge that on or about, on file number 24-21747FH, that on or about February 1 of 2024 in Fairfield Township in the county of Lenawee that you did commit the offense of motor vehicle unlawful use, guilty or not guilty?
Guilty.
All right, and how do you wish to plead to the charge on file number 24-21812FH and our soon to be amended information? I'm sure Mr. Bayanetto has already got that in the works. To count 3, possession of methamphetamine, guilty or not guilty?
Guilty.
And that would have been on February 13th of 24 in the city of Adrian in the county of Lenawee. All right, has anybody made any threats or promises to you to induce you to plead guilty to these charges?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Bayanetto? Has your attorney promised you any other sentence other than the total agreement that was placed on the record, or estimated what any other sentence would be?
No, she hasn't.
Okay, is it your own choice to plead guilty?
Yes.
All right, so Ms. Sebring, on file number 24-21747FH, on February 1 of 2024, were you in Fairfield Township in the county of Lenawee?
Yes, I was.
And at that time, did you take a car, a Dodge Caliber belonging to a Robert Russell Whitehead?
I did drive that car unlawfully, yes. But yes.
Okay, so let's kind of talk about that. So Robert Russell Whitehead owned a Dodge Caliber.
Yes, ma'am.
And you drove that Dodge Caliber
Yes,
without
ma'am.
his permission?
Yes, ma'am.
You didn't intend to steal it or deprive him of it, you just were using it without his permission?
Yes.
That's fine. All right. On file number 24-21812FH, Ms. Sebring, on February 13th of 2024, were you in the city of Adrian, the county of Lenawee?
Yes, ma'am.
And at that time, did you have in your possession methamphetamine?
Yes, ma'am.
Did you know it was methamphetamine?
Yes.
Did you have any legal right to possess methamphetamine?
No, ma'am.
You're satisfied? Okay, it's not 25 grams or anything like that requirement? No, okay. Has the court complied with MCR 6.302B, C, and D? Ms. Underwood?
It has.
Mr. Bayanetto?
Yes, sir.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights and she does have competent counsel. There is a sentencing agreement in place and the court will follow that. I am referring this matter to the probation department for a pre-sentence investigation. You're currently on probation with who?
Sarah Teskey.
Sarah Teskey. All right. So Ms. Adams, what date are we using for sentencing?
July 5th at 8:15.
Are you available July 3rd at 8:15?
Yes, Your Honor.
All right.
It was July 5th, Judge. July 5.
Oh, July 5.
I'm here.
Still available. All right, so we'll set sentencing for July 5 at 8:15 in the morning. Ms. Sebring, you do have a right to be present in person for sentencing, but you can also Zoom. How would you like to appear?
I'll come in person.
In person? All right. So Ms. Teskey will come over and meet with you and do an update to probably your last pre-sentence report. Be honest with her about your background, these events that occurred. She'll prepare the report. We'll provide it to Ms. Underwood. She'll review it with you before sentencing. And we'll see you back on that day at 8:15 in person, okay?
Thank you very much.
Thank you. Anything else, Mr. Van Nettle?
No, Your Honor, thank you.
Ms. Underwood? Thank you. Mr. Smith, Mr. Goldstein will log in a minute. Thank you. I knew there was something going on because you're always on time, you're always present, so. All right, Mr. Williams. No, it's not your fault. It's fine. It's fine. I knew that you're always here, so you weren't at any risk of a bench warrant or anything. So, Mr. Dagmar-Gosian, are you ready?
Yes, thank you.
All right, Mr. Williams, can you hear me still?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Xavier Anton Williams, file number 24-21722FH and 24-21723FH. I have Michael Dagmar-Gosian appearing on behalf of Mr. Williams. And I have Dave McCready appearing on behalf of the people, just because he's sitting there. This is the date and time set for sentencing. Let me get the PSI. So, Mr. Williams, have you had an opportunity to review the pre-sentence report with your attorney?
Yes, ma'am.
Are you satisfied with Mr. Dagmar-Gosian as your attorney and the advice that he's given you?
Yes, ma'am.
All right, Mr. Dagmar-Gosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Mayor, thank you.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Your Honor, none to my knowledge at this time.
Okay. The probation department in this matter, 2 of these counts are misdemeanors, so obviously there's no guidelines. But on file number 24-21722FH on the domestic violence, which is a 5-year felony, the probation department computed the minimum sentencing guidelines to be 24 to 38. And on file number 24-21723FH, count 1, the other domestic violence felony, 19 to 38. Do you agree with that? Do you agree or have any position on the computation of guidelines?
Your Honor, I don't have any challenges at this time.
Okay. Before the court passes sentence, I don't believe I have anyone here to speak from the people or as a victim. So before the court passes sentence, is there anything you'd like to say on behalf of Mr. Williams? And I do acknowledge on the record that there was a sentencing agreement that he would be sentenced to the minimum of 24 months, but it is consecutive to his parole.
Correct, and Your Honor, that's that's really the only issue that I was going to address with the court, and the court is, per usual, is ahead of me here. I was going to indicate that the sentence agreement constructed between myself and the people and with the court signing off on it at the time of the plea was for the sentence to be the 24 months as the 24 to statutory maximum, obviously, as the sentence. The felony cases would be concurrent to each other, but consecutive to any MDOC sanctions that Mr. Williams may incur. But that's really the only issue I needed to address. So I'd ask the court to follow the sentencing agreement for 24 months.
On the misdemeanors, because they were misdemeanors, I was just going to give them credit for time served.
I think that's correct. Thank you.
All right. So, Mr. Williams, is there anything you want to say on your own behalf?
No, ma'am.
Okay. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the class of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence on the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. So, Mr. Williams, on file number 24-21722FH on the count 1 domestic violence, which is a 5-year felony, it's a sentence of the court that you will serve 24 months to 60 months with the Michigan Department of Corrections. Because you're on parole, I can't give you credit for any time served, but on the misdemeanor assault and battery, I am going to give you credit for time served. So I'll give you 93 days credit, and there'll be no probation or anything on that count. Let's see. You're not to have any verbal, written, electronic, or physical contact with Elizabeth Johnston, Delijah Williams, either directly or through another person, or be within 500 feet of their residence, school, or place of employment while on parole. You must pay a crime victim assessment fee in the amount of, I maxed them out, so I'm not going to assess the misdemeanor one. So there'll be a crime victim rights fee in the amount of $130 on count 1 and $68 in state costs. So that would be that file. And then on
Get to, misdemeanor state costs.
I gave I maxed them out.
In the state costs.
I maxed them out. I'm not assessing. On 24-21723FH on count 1, the 5-year felony domestic violence sentence, the court will serve 24 months to 60 months with the Michigan Department of Corrections. There's no credit for time served because you were on parole. Count 2, the misdemeanor assault battery, I'll give you 93 days credit for time served. On that felony case, there is $130 crime victim rights fee and $68 in state costs. During that term of probation, let's see here. No contact with Simone Burciaga, Kayla Young Cook, either directly or through another person. Can't be once you're paroled within 500 feet of their residence, school, or place of employment. And I don't think there's any other terms on the felony sentence, correct, Ms. Holly? I know it's not your file, so I appreciate you filling in on that. All right, so anything else?
No, thank you.
All right, so Mr. Williams, do you understand the sentence or do you have any questions?
Yeah, so those two cases run concurrent, the 2 felony cases they run?
They run concurrent but consecutive to your parole. Yes, thank you for bringing that up, Mr. Williams.
So it's only 24 to 60 months all the way around?
Yes, sir.
I can't hear you.
Yes, sir.
Okay.
All right, any
Thank you, ma'am.
questions?
No, ma'am.
No. All right, so you do have the right to appeal this sentence, and we're going to send over to the jail a set of your notice of right for appellate review for each file. They'll have you initial and date 1 copy just to acknowledge you received the paperwork. The other copies are for your records. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Yes, ma'am.
All right, anything else, Mr. Degemer goes in?
No, thank you.
All right, you're done here. Do you have anything next door?
I'm all set.
Are you done for the day? Okay, I just have something to tell you, but I can tell you some other time. Thanks.
Thank you.
All right, Mr. Williams, good luck to you.
Okay, thank you.
Concurrent to each other, consecutive to his parole. Yeah. Okay, so. All right. Mr. Murphy, I don't have David Goldstein yet. No. So, actually, Mr. Degemer goes in. If you want to step outside, I'll tell you real quick. It's not court, so.
Roy, hi. What's the name of your case? Who's your client?
Edward Benitez.
Yeah.
Nine,
I'm sorry, with 24.
1059, FY.
What's this person?
Joanne, that is a district court case.
Okay, thank you, Ms. McGrain.
He's in custody.
Okay, thank you, Mr. Swan. Thank you, Ms. McGrain.
All rise.
Be seated. All right, I still don't have Mr. Goldstein. He'll be a minute. He's usually in another court somewhere. So I have this file. Is Mr. Tatum here?
Yes,
Are you ready for
I'm
Tatum?
ready. Yes, Your Honor.
Okay, so is he doing okay today?
Mr. Tatum, you seem to be doing okay.
You have a prosecutor in Tatum? All right, Mr. Tatum, you want to go stand by your attorney? Okay. This is in the matter of the people of the state of Michigan versus Jalen Jamal Tatum. We have two files. We have file number 24-21710 FH and 24-21711 FH. Mr. Tatum is represented by Mr. Murphy. This is a date and time set for sentencing in this matter. Mr. Murphy, you received a copy of the pre-sentence report.
Yes, Your Honor.
Mr. Tatum, did you have an opportunity to sit down with Mr. Murphy and review the pre-sentence report?
Yes, Your Honor.
All right, you're very tall, so I need you to speak up so the mic picks it up, okay? Can you
Yes,
repeat
Your
that? Okay, good. So, Mr. Murphy, do you wish to explain, are you satisfied with Mr. Murphy as your attorney?
Yes, Your Honor.
All right, good. Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Does the pre-sentence, do you wish to, let me see, does pre-sentence, he has one prior felony, one prior misdemeanor. Do you wish to, is there any constitutional defect as far as you're aware on any of those convictions?
No, Your Honor.
Probation department did not do guidelines on count one,
Yeah.
but on count, because it's a misdemeanor, but on count two. What? So. So, Mr. Murphy, the heading on the guidelines, is that correct?
Your Honor, may I approach?
Yeah.
There's, piggyback on, it's an older PSI, I don't know if you.
Oh, yep, that's what I was missing.
Don't need to approach.
No, no need to reproach. So the aggravated indecent exposure, the guidelines were 0 to 11 months. Do you agree with that one?
Yes, Your Honor.
Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Tatum?
Yes, Your Honor. In regards to this matter, obviously, Mr. Tatum has an issue. What or how to address that issue is the big concern. Now, obviously, the recommendation here would be for Mr. Tatum to serve a period of incarceration with no probation afterwards. Mr. Tatum is asking the court to consider probation. He's asking the court to consider that because obviously with this issue, perhaps supervision of the court for a period of time would be helpful. The only issue that we have, the only concern, quite frankly, thinking of this case is what actually services can be provided to Mr. Tatum. If there's courses, something like that to try to address what it seems to be an impulsive behavior, maybe sexually impulsive behavior. And again, so I'm not sure if there's classes that can be imposed if probation was ordered. Now, in regards to the matter, I don't believe a long period of incarceration is necessary for Mr. Tatum. Obviously, there is concern with the community, concern with his behavior. But Your Honor, in regards to this matter, he has served a period of incarceration already. So I would believe that release and probation will be appropriate given the punishment he's already served. And again, if there was an ability to rehabilitate him on that probation. Now, Your Honor, again, the guidelines are 0 to 11 months. So if Your Honor was inclined to just do a period of incarceration with no probation afterwards, I'd ask the court to consider maybe less than 11 months on the second count, maybe something like 6 months or something to that effect. Again, 11 months, obviously that's in the guideline range, but at the top of the guideline range. Mr. Tatum, he is young. Obviously, he's very regretful of this behavior. Again, he's trying to figure out ultimately how to address this moving forward, which again is ultimately my concern. If he serves a period of incarceration with no assistance afterwards, if we'll be right back here. And obviously, one of the concerns the court would be aware of with Mr. Tatum is that when he is out of custody, he has been homeless, he has gone to shelters. He is going to try to figure out a housing situation if he was given probation. Obviously, my office, we're trying to assist in any way, shape, or we could. And that does cause issues because at some of those places have been those places where those incidents have occurred. I believe Mr. Tatum, I don't think it's necessary to throw him away and let the key. I don't know. It seems, Your Honor, 11 months.
Throw away the key.
Yeah, I don't know why I couldn't get that out. He's young. He needs some assistance. He doesn't need incarceration for a long period of time, Your Honor. Thank you.
Mr. Tatum, anything you want to say on your own behalf?
No, Your Honor.
Do you have any family here in town?
No, Your Honor.
So your dad's in Texas?
Yes, Your
Do
Honor.
you have a relationship with your dad?
Yes, Your Honor. I spent like a year and a half in college. He got me after graduation, he got me into college, and I stayed there for 2 years in Tyler. And so we had like summer relationships. He like my summer pops in a way. So like every summer he'd fly me out there. So we kind of got that type of relationship. But I haven't seen him in like 5 years. So
Is your mom still, is she in Romulus or Inkster?
how the Inkster of the trade, I'm not sure.
Don't know.
I have to see her in the morning.
So what brought you here?
The case for my first time being out here when I was 16 from Ms. Moses. I ended up coming out here and just been out here since, you know. been
Can you
around-
speak up just a
living-
little bit
living-
for me?
Living around out here since, just been out here trying to find a shelter, a place to go, better myself. Lee and things helping me out. getting
Yeah.
into church and things of that nature.
So when I look at your record, you're gonna end up going to prison if you keep doing these things. You understand that?
Yes, sir. I do.
So anything else, Mr. Murphy?
Nothing further, Your Honor.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence, or the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of law, and protection of society. Have you been on probation here before
Yes, Your Honor.
in circuit court
Yes, Your Honor.
with Mr. Jones?
Yes, Your Honor.
And you absconded and we revoked your probation, right?
Yes, Your Honor.
And you lost your height on that one too?
Yeah, yeah. I think I had went out to Easter, then I came back late and I had.
And then you just never came back.
Yeah.
So, Mr. Tatum, I will give you one chance. But that means you have to find housing, you have to find a job, you have to utilize all the resources Mr. Jones makes available. He's a good probation officer. He will do anything to help you as long as you're honest with him and you follow through.
Yes, Your Honor.
So it's sentenced to the court, you'll be placed on probation for a period of 2 years. You are indigent. So I'm gonna assess court costs in the amount of $350, court-appointed attorney fee in the amount of $450, $130 crime victim rights fee, $68 in state costs. And that is on file number 24-21711FH. There's a $30 per month supervision fee, $60 if we need to put you on a tether. And then on file number 24-21710FH, that's the misdemeanor larceny file. I'll give you credit for time served of 130 days. And there is $75 crime victim rights fee, 50 state costs on that one. During that term of probation, you must obey and comply with all the provisions in your articles of probation. So you're gonna need to find employment. You're gonna need to find a place to live, whether it's a shelter or a men's facility, something. You're going to have to not consume alcohol, because that's what really gets you in trouble. So no alcohol, no marijuana, because that also gets you in trouble. No illegal controlled substances. Maintain employment 30 hours a week. Not to engage in any assaultive behavior. Inappropriate, no inappropriate exposures. Got it?
Yes, sure.
What else? Employment, you have your GED.
Yes, sir.
Good. A diploma or a GED?
GED.
Good,
High
good.
school diploma.
Yep. So I think sometimes with GED, you can get job training funded with a GED, which you can't for a diploma. Not to commit any new crimes, no assaultive behavior, no contact with the victims in this case, not to enter on or walk in front of Musgrove and Company. You have to cross the street if you're gonna go by it, right?
Yes, sir.
What else, Miss Holly? What else can I put in there?
So are you not doing probation for the misdemeanor, just credit for time served?
It's a 90-day misdemeanor. He's already served 130.
So the 2 years probation is just on felony?
Yeah.
Okay, I don't think so.
Nothing else? Okay. So, You're gonna get released from jail today. I'm gonna give you credit for time served, okay? On this file of 130, so on file number, let me see, 24-21711FH, I'm gonna give you credit for time served on 130 days. So my bailiff's gonna hand down to you your notice of right to appellate review. I'm gonna have you initial and date one copy for my records, just to acknowledge you received the paperwork, okay? Is Mr. Jones in the building today?
No.
No. I'm sorry, that's the prosecutor's bench. You have to sit back over there with the defense attorneys.
What about former? Like you get any trouble with
No, Mr. McCready said no, he doesn't like sitting by him.
that? I have people against me too.
So he should report Tuesday morning.
Okay. So Mr. Tatum, if you wish, I don't know if I said it, but if you wish to appeal the sentence, you would fill out the information on that form and mail it to the address on the form within 42 days. Mr. Tatum, I want you to succeed. I don't want you to get any more trouble, all right? Tuesday morning at 8 o'clock, you need to be at the courthouse to meet with Mr. Jones, okay?
Yes, sir.
Over the weekend, don't be drinking, don't be smoking weed, find a shelter, it's warm out, sleep, whatever it is, but stay out of trouble, and Tuesday morning, be here at 8 o'clock.
Thank you.
All right, thank you. And the record should reflect, I've received back a signed copy of the notice of right to appellate review. So, hey, that concludes my morning sentencings. Nobody's. Not yet, but I don't have, oh, I do have David. Never mind, I got David. So Mr. Smith, come on up to the podium. Are you here on the Smith? Okay, and you've been reporting to Mr. Coast, right?
Yes.
All right, Becky, could you have Mr. Coast log on?
Okay.
Mr. Goldstein?
Yes, Your Honor.
Okay, so I'm waiting for Mr. Coast to log on. So this is in the matter of the people of the state of Michigan versus Jesse Allen Smith, file number 23-21555FH. I have David Goldstein appearing on behalf of Mr. Smith, and I have Dave McCready appearing on behalf of the people. I have asked for Mr. Coast to log on because he's been reporting to Mr. Coast. Last I heard, there were absolutely no issues with his performance. And I don't have an updated letter. What is this? All right, and Mr. Goldstein, have you had ample time to review the pre-sentence report with your client?
Yes, Your Honor.
So Mr. Goldstein, your client did arrive on time and he did apologize, and I understood because he's always been here well on time and always appeared, so we knew that it was a misunderstanding. So I told him he wasn't going to be held in contempt for anything. So Mr. Coast is joining us. Mr. Coast, I have Jesse Allen Smith for sentencing this morning. Do you have any updates on him?
I do, Judge. He is doing drug screens with me twice a week. He's been in compliance. He is positive for marijuana. He does have a marijuana card. A lot of times he does test positive for ETG, alcohol, but he doesn't have a no alcohol provision. He's also testing positive for methadone, but he does have a prescription for that. But yes, he's been in compliance. He doesn't miss his drug screens.
Okay, excellent. Thank you.
You're welcome.
All right, Mr. Smith, have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor.
Have you had an opportunity to review that with David Goldstein?
Yes, Your Honor.
Are you satisfied with Mr. Goldstein as your attorney and the advice that he's given you?
I am, Judge.
Mr. Goldstein, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, the only thing that, and I think it's probably just a typo, on the first page where it says plea agreement, it says count 1 only. It says count 2 and 3 and docket 23-155 or 21-555. I think what it's supposed to say is counts 2 and 3 of docket 23-2155. There was another file, but that was dismissed in district court.
Okay, we will make that change. All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Mr. Smith, what's going on with your Jackson County case?
I just haven't addressed it.
It's not warrant status though.
I don't, I'm not aware of all of what.
Right, you know you gotta go take care of that.
Charge and it is in warrant status.
Okay, all right.
I will, is any way you want me to handle it, Judge?
So it's a misdemeanor, but you need to take care of this.
Okay.
Because it's just kind of hanging over your head, and I'm sure every time you get in the car, you're worried about being pulled over.
I
right?
am.
Okay, so, all right, Mr. Goldstein, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
The guidelines are calculated to be 0 to 17 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
Are you going to speak on behalf of the people?
Well, there's an issue that I'd like to bring up, Your Honor. Part of the plea agreement was that he was in at the time we negotiated the plea, and then by the time we took the plea, that he had successfully completed inpatient drug treatment. I don't see that represented in the plea, in the pre-sentence report.
You did an inpatient
Yes.
program. He actually, yeah, I know he did.
That's what I thought, but it's not in there, so I want to make sure that.
So which treatment program did you do?
Sacred Heart.
Okay,
I gave the completion to Darren Cove.
okay.
And
Mr.
Judge,
Combs,
I do have that completion of the actual inpatient. He did go into outpatient after that over at Catholic Charities. And he was dismissed from that program unsuccessfully. But he did in fact complete the inpatient portion.
why were you unsuccessfully dismissed?
So, Your Honor, me and the therapist there had a disagreement in an open group. And I was asked to not return over something very, very ridiculous. I don't guess I should go into, but it was extremely ridiculous. This was 8 weeks ago. Since then, I have been attending groups at the methadone clinic that I go to. That's my therapist there. I've been going there since I haven't been going to Catholic Charities.
Okay, so you have now started outpatient
Yes.
treatment with someone else?
Yes.
And what's his name?
James.
James
I don't know his last name.
Gooley? Okay. All right, so good. So that was my next question. Have you continued it with someone else? So there was completion of inpatient treatment, Mr. McCready.
What's the name of the outpatient you're going to now?
It's the Passion of Mind in Monroe.
Okay, good. Okay, guidelines was 0 to 17. You didn't object to those. Mr. McCready, anything else? Mr. Goldstein, anything you want to say on behalf of Mr. Smith?
No, Your Honor, I think would ask simply the court to follow the recommendation. I think Mr. Smith has earned it. And not only has he not had any additional problems with the law, but he did complete the inpatient program and is following up with his aftercare.
Okay. Anything you want to say on your own behalf?
I'd like to thank everybody for taking the time out of their day to come here and address this, and appreciate everyone for being here.
Okay. All right, in determining are you still in Jackson County? Are you
No, I live in Blissfield now.
You're in Blissfield? Okay.
Yes. Yeah.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history. I thought you lived in Jackson at one time, didn't you? No, I'm sorry. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law and the protection of society. So it's a sentencing court that you'll be placed on probation for a period of 18 months. I'll give you credit for 6 days jail you've already served, okay? During that term of probation, you must obey and comply with all the provisions in your articles of probation. There is $750 in court costs, $130 crime victim rights fee, $68 in state costs. She put a DNA fee. There's a $60 DNA fee, $30 per month supervision fee, $60 if we have to put a tether on you. There is no, is there a law enforcement restitution? No, I don't see any restitution. Now, because you have a history of substance abuse, you obviously have a medical marijuana card, but you can't use any illegal controlled substances. You must test as required by the probation department. You can't live with anybody who's using illegal controlled substances. You can't be with anybody who has them or paraphernalia. Are you working?
Yes, full time.
Good. Maintain your employment. Only use your prescription drugs as prescribed by your physician. Make sure that your physician knows that you're an addict, because they will give you different treatments. Because you know, one OxyContin could probably spin you into relapse, right?
Yeah.
So must report monthly or bi-weekly as required. Do you have your GED?
All but the math.
Okay. That's, yeah, okay. So you need to finish that, all right? Adrian Community Schools is here in Adrian. It's a wonderful program and they actually assist you. So that might be something to look into. Notify any change of address, employment status, contact with the police, not to engage in any assaultive, abusive, threatening or intimidating behavior. Not to use any weapons. Anything else, Sally?
I do think any of this treatment verification needs to be brought to the schools too.
Yep.
Okay.
Make sure you bring verification of all your treatment programs.
You should report to her Tuesday.
Yep. And you're going to need to report to her Tuesday morning at 8 a.m. 8 a.m. or 8 to 10?
8 a.m.
8 a.m. is fine. And then I want you in the next couple of weeks to take care of the misdemeanor in Jackson. All right. It's looks like it's a 93-day misdemeanor.
What will happen if I will go turn myself in? Will I be able to be bonded out that day?
So I'm not Jackson County.
I understand.
I'm assuming if you turned yourself in, they probably would release you, but I can't guarantee that. Might want to retain Mr. Goldstein to represent you on that one. I don't know, but you know, I can't imagine they would, but I'm not a judge in Jackson County. So, but you need to take care of that, because if you don't take care of it, you get arrested. If they pick you up, you might not get out, right? So they'll probably set a bond, and worst case scenario, you have to post a bond. Okay.
Yep.
But in the next 2 weeks, I want you to go take care of that.
Yes, Your Honor. Right. I'll give you my word.
Okay, good. So my bailiff's going to hand down to you notice of right to appellate review. I'm going to have you initial and date one copy for my records. The other copies are for yours. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Anything else, Mr. Goldstein?
No, Your Honor.
All right, so go ahead and initial and date that.
Let's date on that.
It's okay. Mr. Smith, you've done exceptionally well. Hold tight to that. Make sure we don't relapse, okay?
Yes.
And if you do, admitting it and getting help is the best thing to do. Don't lie about it and don't run off, all right? All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Your
The
Honor.
record should reflect, we've received back the signed copy of the notice of right to appellate review. Thank you, Mr. Goldstein. Okay, so I have jail. Miss Adams, the jail disconnected, so I'm gonna need the jail back.
Who did you need from the jail, Judge?
Edward Bennett, I'll call him. Don't worry, I'll call him because he's down on the first floor. This is Judge Anslone. You guys were kind enough to get Mr. Benitez for me, but I was in the middle of doing a million sentencings and I'm sure you needed the room. Can I get him back?
Yeah, are you ready?
I am absolutely ready this time, I promise.
All right, we'll have her, I'll have her put it back in.
All right, thank you. Bye.
That, you need me for that?
No.
Yes, thank you.
Bye, thanks. Are you here in Williams? Mr. Goldstein, do I have anything else with you?
No, Your Honor, I just haven't logged off yet. Actually, I'm chatting with Andy Borders that I haven't seen in a
It's so
long time.
nice to see him again. I know you guys are like trying to have court and stuff, but Dave and I are having a conversation, so we just need some time.
You look
You're fine,
nice
I'm
and
here all
tan,
day.
Angie.
I just got back from Mexico.
Where?
It's Cancun, and I just got over the Mexican flu, so I don't recommend it.
Gotcha.
The other attorney, yeah, Mr. Goldstein was there, and then Angie, your other running friend also, I think her husband got that same flu when they were there last weekend.
3 out of the 9 of us got it, and I ended up getting an IV yesterday because it was so, I couldn't even think. I couldn't work. I couldn't do anything. I will never go back, ever.
Mr. Goldstein,
Yes,
I think
it's
goes
been
yearly.
so nice to see Dave. I was mid-sentence, Dave, responding. And we're just hanging out. Nothing better to do.
It's okay. Feel free. It's no problem.
Okay.
Angie, we'll talk later, okay?
Yeah, we caught up. We can stop the chat.
Thanks, Judge. See you later.
Sounds like they need a breakout.
I know.
That would have been better. Thanks for the recommendation.
Can always ask. I would have done it.
If it, if Chris was on point, it would have come a little sooner.
Lawyers turning to. Okay, thank you.
Yep.
Okay, so this is in the matter of the people of the state of Michigan versus Edward Mitchell Benitez Jr., file number 2024-1059 FY. I have Dave McCready appearing on behalf of the people, and it looks like I have, let me see here to the back page. I have attorney, want to identify yourself for the record?
Very well. Peter Samoris, your Matt
Samoris.
Bennett. And of course, Mr. Benitez is in custody.
All right, and your P53084. It's Samoris?
Samoris, thank you, Your Honor. It's
All
been a
right.
while.
It has been a while. Okay, so, and Mr. Benitez is appearing from the Lenawee County Jail. It's my understanding this matter, what was this set for in district court today?
Ma'am, thank you, Your Honor, if I may. Your Honor, it was really set for self-surrender, and there was an arraignment, I guess, that was done, but we're here today because there's shocking. I wanted to address the issue of bond, Your Honor, and I appreciate the court hearing this on short notice.
Okay, so it was set for, he turned himself in.
Turned himself in. The warrant is not even 48 hours old.
Okay, I didn't ask that. I asked if he turned himself in.
Yes, he did.
So the complaint felony shows that Mr. Benitez is charged in count 1 with criminal sexual conduct, 2nd degree, which, let's see, a victim at least 13, but less than 16. And there's a coercion aspect to it. So I'm not sure what that is. Count 2, criminal sexual conduct, 2nd degree. Victim under the age of 13. And both of those are 15-year felonies. And then we have criminal sexual conduct, 2nd degree under count 3. Victim under 13. Count 4, criminal sexual conduct, 2nd degree. Victim under 13. So all of those are 15-year felonies. So Mr. Benitez, were you arraigned on those charges?
I believe so.
Okay, so were you there when he was arraigned?
I was there, Your Honor, but I was not able to address the issue of bond.
I haven't gotten a bond yet,
Yes,
so
yes,
my
yes, I
question
was there.
was, you were there and he was arraigned?
Yes,
We need to rearraign him and go through the charges again with him, or?
I don't think so, Your Honor. I
Okay.
don't know if the court can provide a copy of the complaint. I don't need a reading of the complaint, but I just did not receive a copy.
Okay, Ms. Adams, could I get a copy of the complaint from Mr. Samores? Okay, all right. Okay, all right, and did you enter a plea of not guilty on behalf of your client?
Yes, sir.
Okay, all right, and then it's my understanding that he was arraigned by a magistrate, correct?
Correct.
Okay, and that you wanted to address bond.
Yes, Your Honor.
And then the reason this came to my attention is it's my understanding that you were yelling inappropriately at the staff on the first floor.
I disagree with that assessment.
Okay,
Not yelling.
well, what I'm gonna say to you is that I appreciate that you disagree with that, but just going forward, just understand that I expect everybody in this building to be treated with respect. It includes attorneys.
I understand, Your Honor, but since the court brought it up, you have a full record. Ms. Gannon sarcastically says, "Have a nice day," and that's not appropriate.
Okay.
Also, when I come into the magistrate, to come into the clerk's office, I was very respectful.
Okay, that's
showed-
fine. I'm not gonna get into a discussion. I was just made aware of that. And that's the only reason I'm seeing you today. But I just, going forward, I want everybody to behave appropriately in my courthouse. Thank you.
But for the record, not every unpleasant comment amounts to a contempt of court or anything.
I wasn't threatening you with the contempt of court. I was just advising you what I expect in this courthouse.
Understood.
Okay,
And just.
so now you can address bond.
Thank you, Your Honor. Your Honor, I've been in touch with the prosecutor's office to a lesser degree, but on a regular basis with Detective Lamar Ruffner for over 2 years. I've had this case for over 2 years. The alleged victims in this case went through a CPS procedure. The allegations in this case keep fluctuating. For all the reasons pursuant to MCR 6.106F, a bond set at 200,000 cash surety is not only an abuse of discretion, but it shocks the conscience. It does not give any credence to the presumption of innocence. As this honorable court is well aware, pursuant to all the reasons and factors regarding bond or MCR 6.106F, a magistrate can hear reasons regarding bond. Now, in this matter, I've had communications with Detective Ruffner. In fact, the reason why I knew the warrant was issued was because on Tuesday afternoon, he sends me an email. He was kind enough to send me an email saying, your client's prosecutor's authorized charges. I take that back, not immediately, but the next morning I called the court. I spoke with the magistrate. I said, I cannot bring him in today. That was yesterday, Wednesday, the 22nd, but I can bring him in on Thursday, the 23rd, which of course, here we are. And I brought him in. He's here today with his wife. He's been a lifelong resident of Michigan. He's been a longtime resident of Lenawee County specifically for over 7 years, probably closer to 7.5 at this point. He has an excellent reputation. He has absolutely no prior criminal convictions of any kind, no misdemeanors, no felonies at all. Also, he's a disabled veteran and a decorated veteran. He's been honorably discharged. He has every reason in this case, really, a personal cognizance bond wouldn't be out of the question. But even if the court disagreed on a PR bond, certainly a 200,000 cash surety bond is an abuse of discretion. That's putting it politely. When looking at all the factors pursuant to MCR 6.106F, again, my client is a lifelong resident of Michigan, longtime resident of Lenawee County. He's a disabled veteran. He served in the Persian Gulf War, a decorated veteran. He's also did a self-surrender. The warrant was just issued on Tuesday, May 21st. And here we are, less than 48 hours later. He turned himself in. He's been cooperative. With respect to other factors under MCR 6.106, as far as his reputation in the community, he's helped out law enforcement in the past. In the recent past, there was a stabbing not far from his house. And he provided all the camera work to the police, cooperated with them. And with his assistance, they were able to apprehend and finally, I believe, convict this person who did a stabbing just a few years ago. So every indication is that he will appear for court, and he was here. In fact, I received an email from Detective Ruffner in October of 2023 stating that, well, gee, you know, if he passes a polygraph test, maybe they won't even charge him. Okay, but there are factors there. He has PTSD, he has anxiety, he's also a diabetic, so various medication makes the issue of a polygraph exam complicated. I was discussing that off the record with Mr. McCready. I don't understand why any of these reasons couldn't be really articulated at the arraignment level in district court. And again, I'm not here to relive what happened, and I apologize for any if I seem taken aback, but I was taken aback under these circumstances, Your Honor. And I don't think it's when we arrive in the clerk's room, in the clerk's office, filling out the paperwork, everything's pleasant. And then the magistrate doesn't even look at me. It's very odd. And it's almost like this dressing down of a defendant. And the proceeding is, I think, hostile. I don't know if it's designed to intimidate. And even when I went to the magistrate's courtroom, there was another counsel who was being, whose case was before mine. I go into what? The bailiff, he said, could you please leave? Your case is being called yet. I said, no, I want to sit here. It's public. And he didn't argue with me. So I do apologize if I came across as a little upset, but it's upsetting. This type of bond does shock the conscience, especially in light of the fact that for over 2 years, I've been dealing with a detective. I've been dealing with my client. He's not going anywhere. His wife, Jody's in the courtroom today. He deserves better. Anybody in that position deserves better, but I think especially a person who's that age, no prior criminal record, no criminal history whatsoever, a man who fought for his country, and to be slapped in the face like that is outrageous. And I think I understand about no contact provision. He doesn't want to have any contact with these alleged victims. Both, I believe, are the granddaughters of my client's wife. The mother of these two individuals.
All right, so I'm not trying this case yet. I mean, it might come up to me at some point. But you know, I'm glad, you know, a lot of these things. Okay.
I just want to just quickly say, to the extent that MCR 6.106F allows for consideration by the court of the strength of the case, I would say, Your Honor, that the allegations keep changing, and that the mother of these two girls has, I believe, had her parental rights terminated. And I'm going to share with the prosecutor disturbing texts and sexualized images that come up and whatnot, but I know the court's not here to try it. I would just say, Your Honor, that I think he's an excellent candidate for a PR bond, and certainly a $200,000 cash surety bond is an abuse of discretion, to say the least.
So, Mr. McCready, district court procedure, typically the arraigned and a bond is set within a few days. Is that correct? The typical procedure, and then is there a formal arraignment? Or is it set, go to probable cause?
The first appearance that I would make would be on a bond hearing shortly after the arraignment.
Okay, all right, and there are no district court judges here today, is my understanding, Ms. Cannon. Okay, very good. All right, so Mr. McCready, do you have a response?
Yeah, I'm fine with having a bond hearing today and just being it. And I haven't had a chance to look at our file. I do agree that he appears to have no prior criminal history. And I do agree that this investigation into these allegations has been going on for quite some time, perhaps up to 2 years. And in that time, he's not fled the jurisdiction, knowing that he's being investigated. So it does seem like some reduction in bond would be appropriate. The main concern that I have is that not only did he not have any contact with the complainants in this case, but that he have no contact with any underage females whatsoever. I do think that given the serious nature of the charges, they're 15-year felonies, that some cash bond would be appropriate, but I'll leave it up to the court's discretion to determine what that would be.
What would you think would be appropriate?
$5,000
per count?
Correct.
Okay.
May I address that, Your Honor?
Sure.
The family does not have a lot of money, Your Honor. I know right now it's in a cash surety form. If the court is inclined to do a $5,000 bond, we would respectfully request that they can apply to all funds. So not only that, but perhaps more importantly, as the court is well aware, a cash surety bond, we lose that money to a bondsman. And I would just respectfully request that if the court is going to set a cash bond, that it be a pure 10% bond. That way, at least he and his wife can get that money back at the end of the case. He's going to be here for every proceeding. Whereas if it's even a $25,000 cash surety bond, well, then he'd lose $2,500 to a bondsman. And I just think under the circumstances, his cooperation, the fact that this investigation hadn't happened, I got involved in the case, I'll tell you the exact date, May 20th, 2022. So it's been a little over 2 years since I've been involved, which means it's probably been at least a few weeks before that. There's been a CPS case involving, I think these allegations were I think brought up in a CPS case, but in any event, Your Honor, he'll be here for everything. He's not in a position to leave his jurisdiction, nor does he want to. This is his home. He takes his medications, he's here, he's cooperative, he's a military man, and I think every indication is that I think he is a good candidate for a PR bond. But even if the court disagrees with the PR bond, I would just respectfully request that it be in a pure 10% form as opposed to a cash surety form. Thank you. And may I address just one other matter, just for the record? I guess pursuant to MCL 600.8511 parenthesis F, I think the district court can't hear these things. So I guess I'm at a loss.
They what?
The district court, excuse me, the magistrate at the district court level can hear these arguments that they can't just, oh, we just set bond. If you don't like it, there's the bond hearing 2 days away. I think the whole procedure is, I think, irregular. It's inconsistent with what other courts do, for what it's worth, in other counties, and I practice in the 83 counties. I can say with confidence I've been in at least 50.
So I am not the chief judge of district court.
I
So if you have an
understand.
issue with that, you can bring that up with either the governing bodies or the chief judge of district court.
Understood, Your Honor. It just seems
Okay.
irregular to say the least.
Okay, well, I know that I've practiced in probably 10 counties in Michigan, and a lot of things are different in every county. So, but I'm not going to speak as to your alleged irregularities, because I'm not a district court judge, so I don't know what the standards are for that court. All right, so what I'm gonna do is set a 2,500 10% bond on each count, so that way it can be paid to the court. I am going to order that he is not to leave his home except for doctor's appointments and court hearings. And he is not to go anywhere near or have any communication with anyone under the age of 16. And no contact with the alleged victims in this matter. What else would you like, Mr. McCready?
That was it, Your Honor.
Okay. And then, is there a court date?
Your Honor, there's a PCC set for May 28th, and I did discuss with my client the possibility of waiving the 21-day rule. And I say that because on June 6th, I've got a medical appointment, and that's the prelim date, so I'm not sure. I guess we can discuss that at the PCC date. I know right now there's a bond hearing set for May 28th, but we would.
Will
waive
this
that.
take off the bond hearing? Ms. Cannon, the bond hearing would be removed now?
Yeah.
Okay. So it'd just be your probable cause date.
Very well.
Okay, and so, Mr. Benitez, you'll be released from the jail today once someone has posted that with the court. And do they post that in district court or the jail? Where do they post that?
Don't do that. We don't actually take 10%. We never have. They can do 10% with
All right.
the body agency.
No, I'm sorry, I didn't mean to interrupt. Your Honor.
So, Ms. Fern, if you want to speak, you have to come up here. Okay. Hold on, my boss is coming in too. Okay, by constitutionally, you have to accept a 10% bond. But I will tell you that Phyllis Escott does them up here. So if you want to ask her what the procedure is, you can. We are required to accept it. So, okay, so they'll talk with my supervisor on my floor, figure out how to do that, okay?
That you're talking to me, Your Honor?
Yeah.
Okay, very well. And I don't know if my client's wife is here. I don't know if she has the $1,000, so I take it $250, 10% for each count, get $1,000, and then he would be released, and that can be paid directly to the court without having to go through a surety or a bondsman.
Right.
Thank you very much, Your Honor.
All right, and Ms. Cannon, you can call Ms. Ms. McGrain, because that issue just came to the forefront up here too. Okay, all right, anything else?
Not for me, Your
All
Honor.
right, very good, and have a good day. Thank you.
Thank you, Your Honor. Nice to see you.
Do you want the file, Ms. Cannon?
Thank you.